Do I really need an attorney to go to probate in Missouri? Here's the honest answer from a probate attorney. Hi, my name is Dan Schnurbush. I'm an estate and probate attorney in St. Charles, Missouri. And today we're going to talk about when you need an attorney to go through the probate process in the state of Missouri. So to get it out of the way up front, generally you have to have an attorney. It's just required by law, unfortunately. Now, there are certain situations where this is not true. So let's go through some of those. Here are a couple of situations where you might be able to handle probate on your own without an attorney. The first one is if you qualify for the small estate affidavit procedure in some counties. So basically, a small estate affidavit can be filed to probate a deceased person's estate whenever their property subject to probate, after the subtraction of debts and expenses, is less than $40,000. So what do I mean by after subtraction of debts and expenses? So let's take an example. Let's say you have a house worth $100,000 and you have a $70,000 mortgage on it. So the net equity in the house is $30,000. In this case, the house would qualify for going through Missouri probate under a small estate procedure. Okay, so you get to subtract those liens and expenses. Now, which expenses the probate judge is going to let you consider a valid subtraction is going to depend from judge to judge and county to county. Some will let you count the funeral bill. Some will let you count other claims that you might have against the estate beyond the funeral bill. But in general, you're going to be looking at debt that is encumbering or attached to the asset going through probate. Same thing with like cars and things like that. Okay, so if you qualify for the small estate, this has to be filed by a family member. You can file it with a will or without a will. A small estate can be filed within a year of death or beyond a year of death. The only important thing is that the main important thing is that the property is less than $40,000 in value after subtracting debts and expenses. Now, some counties in the state of Missouri will let you file this without an attorney. Others will not. So if you go to places like St. Louis County, St. Louis City, I am not 100% sure about St. Charles County. I believe Jackson County on the Kansas City side requires an attorney, but I'm not sure. You should check with your probate judge or your probate clerk in your county or the county where the deceased person had property. So like, let's say they left a house in Jefferson County. You would be filing in Jefferson County. So where you file can depend on the situation, but generally you file in the place where the property sits. Okay. So yeah, some counties will require you to have an attorney, others will not for a small estate affidavit. The other kind of application in probate that generally does not require an attorney, no matter where you're at, is a refusal of letters application. So there are three kinds of refusal of letters applications in the state of Missouri. The first two are the first one is if you're a spouse of the deceased person and the value of the estate is under a certain amount. The second one is if you're a minor child or the parent or guardian of a minor child of the deceased and the estate is under a certain amount. Or the third one is if you are a creditor of the deceased. Now let's go through these. If you are a spouse, generally you're allowed to claim the estate up to a certain amount of money. Depends where you're at. In St. Louis County, that amount is generally about $24,000. In St. Louis City, that amount is generally about $20,000. These can be fudged a little bit sometimes, depending on if you can prove up the value of the income that the deceased spouse was providing to the survivor and other variables. But generally, those are their rules of thumb, is that you got to have the estate below that amount and be the surviving spouse in order to file a spousal refusal of letters application. But generally, if you qualify, it can be filed without an attorney. To figure out if you need an attorney in your county, you should always call the probate clerk of the county in which the deceased person left property. Okay? The other type of application that you can sometimes file without an attorney is a minor refusal of letters. So a minor child of the deceased can either file the petition or have the petition filed on their behalf by their parent or guardian. Okay? And same rules. Generally, the estate has to be less than a certain amount in order to qualify. okay? And if there are both minor children and a spouse, the order can in some cases allocate the amount to go to the spouse or the child. This is a little less common, but it can be done in some cases. Now, the third way to get through probate without an attorney is to file as a creditor of the estate with a creditor refusal of letters application. Now, this method will work in very discrete situations. Number one is by statutory law, the amount of the probate estate has to be less than $15,000. So it works pretty well for like used cars and small bank accounts, things like that. The other thing is that you have to be a creditor of the estate. In many counties, they have started requiring that the bill be for the funeral, because funeral costs have one of the top priorities as creditors over the estate. If it's a subordinate claim, like something like, oh, so-and-so owed me money, that's a lower level claim that has lower priority than a funeral creditor, right? So if you paid the funeral bill out of your own pocket and it's on, with your money, and you signed on the funeral contract and you have a paid receipt for it, you might be able to file as a creditor. And this could be true if you're an adult child, for example. These are the most common situations we see. If you're an adult child who's no longer a minor and there is no spouse, and you need to claim a small asset under $15,000, in that kind of situation, you might be able to file a creditor refusal of letters application. Now, again, this only works if there is no spouse and are no minor children. But in some cases, it can be a good fit, and it is often one of the only applications that can be filed without an attorney. Now, it's important to note that in the state of Missouri, a corporation or an LLC can only appear in court through an attorney. So this only works for individual creditors, right? So if you're a corporate creditor and somebody, the deceased person paid you money or owes you money on like a credit card bill, for example, probably not going to be able to use this method at all because it's not a funeral bill. But you're also going to have to file through an attorney if you want to waste, the energy and effort doing that. All right. So here are some situations where you're definitely going to need an attorney. One is if you're in full probate estate administration. This situation occurs whenever you're within 1 year of death and the estate value exceeds $40,000, right? Net of fees and expenses. So the small estate procedure doesn't apply and we're within 1 year of death. By statutory law, section 473.153, subsection 7, you have to have an attorney to represent and appear before the estate and to have legal guidance relating to the estate. So in general, you're gonna have to have a lawyer if you have a full estate administration, okay? Other situations where you don't have to have a lawyer, but it's a really good idea. One is if you have a contested situation where you're fighting over the admission of a will or the appointment of a representative. In these kind of situations, you pretty much have to have a lawyer because unless you're going to do a lot of research and learn how to figure out how to prosecute a claim against somebody or the rules around asserting challenges, everything is very, very technical. And if you don't follow the rules, somebody who's defending themselves against an attack and does have an attorney is going to win every time, right? Because they're going to know the rules that they can rely on. They're going to know the time limits that you have to deal with. They're going to be in a much stronger position to fend you off if you have some type of challenge that you wish to assert. So in those kind of situations, it is usually going to be a good idea to have an attorney. Now, in some kinds of situations where it's a little less adversarial, where maybe you just need to make sure somebody knows that you are alive and you are an heir, it might be as simple as getting a birth certificate and sending it and be like, hey, you guys forgot to put me on the heirs list, but I am in fact a child. They might change their tune real quick without a lot of fighting. So it really depends on the situation and the circumstances that you're in. But most of the time, if people are trying to fight you on something that you're trying to assert in the probate court, you probably want to at least talk to a lawyer and possibly retain one. The other kind of probate application where you are going to need an attorney in most cases is what's called the determination of heirship. So this is whenever the person has been deceased over a year, but the property exceeds $40,000. So it still doesn't qualify for small estate treatment, but we're beyond a year. Now, this kind of probate is not as comprehensive as a full estate administration. We don't have to go through the creditor claim period and all that. We just file a petition with a lot of information and then have a court hearing in front of the judge. Generally, these petitions are going to require an attorney. But again, check in your county with your probate clerk to see what kinds of probate applications may be filed without an attorney if this is a concern for you. So here's some risks of trying to handle probate on your own, even if you can. You got to be wary of personal liability. So as a representative, as a small estate affiant, as somebody who's trying to claim an estate without an attorney, you got to make sure that you get everything right. Okay, so the first step is you've got to be able to get it through the court's approval process, right? And that can be a pain in the butt. You've got to get your asset valuations correct. If there are any tax obligations that need to be dealt with, you can be on the hook if you take over control of an estate and don't handle that properly. If you don't notify creditors properly and you close an estate and distribute the property to yourself, there can be situations where you could personally be responsible for paying that creditor. If you distribute the property wrong or you don't realize what the proper heirship distribution is, because sometimes this can get really complicated, especially if you have like half siblings and people who are deceased. How does their share split? How much percentage does this one get? If we have like a grandparent dies and 2 children are living, but one's deceased and one has 2 kids and one of them is deceased and one of them is a half sibling, and like it can get really, really complicated how to allocate those percentages unless you know what you're doing. So making sure that you hit that asset distribution correctly. And if you don't, you can get yourself in trouble with some of the other heirs. The other reason to consider having an attorney, even if you can theoretically do it without one, is the time and complexity. Again, there are lots of different variables that unless you're going to spend a lot of time researching to understand it correctly and confident in your ability to interpret and apply the law, you can introduce delays. So probate is notoriously a slow process, and part of the reason is that judges, in many cases, act like goalies. They don't always, in a probate proceeding, it's usually not uncontested, and they act more in a kind of goalie role, where they're making sure that you're following all of the requirements rather than like deciding among disputes between parties, right? So generally the judge is the person that you have to satisfy, and they may have strict requirements about what they want to see and what kinds of proof they want to see in order for different things and different kinds of petitions to be effective, right? So when you're an attorney and you do this every day, you know which judge is going to require what. We can collect the documents up front, and we can prevent a lot of delays in going back and forth. Because sometimes what you'll see, especially in busy counties, is you'll submit an application, it might be missing something, but the judge might not look at it for 2 months. They look at it, they tell you, you're missing something. You file it. They may not look at it again for 2 months. They tell you, oh, you're also missing this other thing. They wait 2 months again, or, you file it. So it can end up causing these dramatic delays because of the way that counties go through their dockets, right? So if you hit everything correctly on the first try, because you know what you're doing, it can dramatically expedite the process, okay? The other thing to be wary of are statutory deadlines and which kinds of documents are required. But deadlines are a big one. So there are all kinds of things that you need to be very careful about in terms of when you actually file. Certain things can only be filed at certain times. Other things must be filed within a certain amount of time. For example, wills have to be admitted to probate within a year in Missouri. Creditor claims need to be filed in open full probate administration within a year in Missouri, right? So there are important deadlines to be very careful of. And if you're not aware of those, you can easily blow them and get yourself into a big problem. Now, I understand that cost is a consideration for some people when going through probate, right? And there are multiple ways that you will see attorneys' fees handled, right? So at a minimum, in most full estate administrations, there's a minimum statutory percentage that is set by law under Section 473.153. Now again, that's a minimum, right? So it's a floating formula that's based on the value of the estate. Now, interestingly, this is also the same fee that is allowed to the representative themselves. So the attorney and the personal representative, you, the person doing the job, are actually entitled to the same minimum fee. And that increases as the estate gets larger. The percentage gets smaller, but the total number gets larger, right? The other way that you sometimes will see attorneys charging for fees is on a flat rate basis or on an hourly basis. An hourly basis is kind of the more traditional, conventional way to work with attorneys. At our firm, we tend to do a hybrid approach where we will charge a minimum flat rate fee or the minimum statutory fee, whichever one is higher, right? So if you get to the end of the probate and you've figured out that the minimum fee is higher than the flat rate, then we take the minimum statute. If the opposite is true, where the flat rate is higher, then we take the flat rate. Okay, so that's kind of how we do it in most of our full estate administrations. All of our other cases we handle on a totally flat rate basis. So you know exactly what you're getting into and whether it's going to be worth your investment. What I tell a lot of people is, like, if you have to spend X amount of dollars in order to get Y amount back, like let's say you have to spend a few thousand in order to get even 15 or 20,000, not a huge estate. But if you get it back in a couple of months, I mean, that's a pretty good return on your investment, right? It's better than you get in the stock market. So if you're going to try to represent yourself, here are a couple things you need to do. You need to thoroughly review any estate documents that they left, wills, trusts. What does it require you to do? Be very clear that you understand who the beneficiaries are, who the trustee or the personal representative is, who's in charge, and how is stuff supposed to be divvied up. Do your own research on the procedures in your county, as well as the state and any state level rules that are applicable as well. A way that I really encourage people to take a look at this is to look through, just Google and see what you can find. The other thing you can try is using ChatGPT. If you don't have a free account with ChatGPT, I encourage you to set one up. And it should have the search mode enabled, where it's able to help you find relevant Missouri statutes and procedures. It's not perfect, it messes up all the time, but it's very, very helpful in terms of orienting yourself and getting quick answers. Sometimes the answers are correct, sometimes they're not, but you can usually figure that out by reading through the statute. So if you're gonna represent yourself, make sure that you have something helping you navigate and understand what the rules are. Consider consulting an attorney for initial guidance to get your head around what you might need to file in order to try to represent yourself. Maintain detailed records of anything that you do. If you're taking money out of the estate, if you're putting money in the estate, if you're distributing anything to anybody, if you're selling anything, maintain accurate records. Every receipt that you incur on behalf of the estate, make sure you're getting bank statements. If you open a full probate administration, your attorney needs to be telling you that you should have an estate bank account open so that you can easily keep track of money in and money out of the estate. Now, be prepared. If some complication arises and you get stuck, just be ready to call an attorney. You might need help to finish things out. Lastly, you can also call your local probate office and probate clerk. Sometimes they can give you some basic guidance about helping you file and what to file. Most of the time, they'll tell you, sorry, we can't give legal advice, you need to talk to an attorney. But sometimes on very basic things, they can give you more practical steps, like, hey, if you want to file this, here's where you file it, here's how you do it. That kind of stuff, they can oftentimes be very helpful. So when you're deciding whether to hire an attorney or not, you need to evaluate the estate size and complexity. Do I qualify for any of the small estate or refusal letter procedures? Am I comfortable with this stuff? Do I feel like I can read these documents and these instructions, understand them and apply them and get all the stuff that the judge is going to ask me for? Am I comfortable dealing with that back and forth with the court? Do I have the time to deal with this? It can be time consuming to be going back and forth with the judge and the court and collecting the information that you need and getting it on the paper in the right format, and filing all the things that you need to file. Do you have time for this? And also look to the requirements of your local probate court. Are you even allowed to proceed without an attorney for the kind of thing that you're doing? If not, you may as well cut your losses and call somebody right away and get it going, okay? So, in conclusion, while it is technically possible in some situations to do probate on your own without an attorney, you should evaluate those. You should see if they apply in your situation. You can save yourself some money, possibly, get it done easily. Sometimes this is the only way to go. Like if you have a $2,000 bank account, it's probably not going to make a lot of sense to pay an attorney to help you gain access to that account. But if you can find a cheap way to get into it through a refusal letter application or your own small estate, it might be worth a try. So if you have more questions about this, don't hesitate to reach out. Again, my name is Dan Schnurbush of Schnurbush Law here in St. Charles, Missouri, right? There should be information in the description below to reach out and get in touch. Appreciate the time, guys. Follow us, like, and subscribe if you want to learn more about Missouri probate. Until next time, take it easy.